Bienvenue à toutes et tous. Good evening and welcome to everyone. Given the international character of this event and the fact that many people are connected from several countries, I would like to apologize in advance to those of you that are not French speakers, or at least that do not have a passive knowledge of French. After consultation with the organizers, since the rest of the event will take place predominantly in English, it has fallen upon me to save the French-speaking honor of the Université Libre de Bruxelles. Therefore, the rest of the speech will be delivered in French. But rest assured, the speech is just introductory, so you will not miss much, and it's not that long. Mon nom est Vaios Koutroulis, et c'est en ma qualité de vice-doyen aux relations internationales de la faculté de droit et de criminologie de l'Université libre de Bruxelles que j'ai été appelé à délivrer ce discours introductif. Notre rectrice, Anne Michos, ainsi que la doyenne de la faculté de droit, Julie Allard, devaient être présentes au conseil d'administration de notre université qui a lieu en ce moment, donc je vous prie de les excuser. L'Université libre de Bruxelles et la faculté de droit sont ravis d'accueillir en cette année 2021 l'avocate générale honoraire auprès de la Cour de justice, Eleanor Sharpston, au titre de la chaire Francqui 2021. Les chaires Francqui sont attribuées chaque année à des professeurs belges et à des personnalités étrangères sur proposition de l'université belge par la Fondation Francqui. Ceci a lieu dans le cadre de l'objectif de la Fondation, qui est de promouvoir le développement du haut enseignement et de la recherche scientifique en Belgique. Ainsi, mes premiers remerciements vont à la Fondation Francqui d'avoir, par le biais de l'attribution de cette chaire, permis à tous, notamment à nos étudiantes et étudiants, de bénéficier du cycle de conférences d'une des plus éminentes juristes du droit de l'Union européenne. Je souhaite également remercier les promoteurs de la chaire, promotrices en l'occurrence, Emmanuel Bribosia et Cecilia Riscala, et plus largement le Centre de droit européen et l'Institut d'études européennes pour la coordination de l'organisation de la chaire. Mes remerciements vont aussi à Benjamin Lachterman et Alexandre Spetchinski de la faculté de droit et de criminologie, à Maria Isabelle Soldevilla et Ilaria Gambardella de l'Institut d'études européennes, ainsi que à Sophie Leclou du Centre d'appui pédagogique pour la communication, la diffusion et la mise en place technique de la chaire. Enfin, j'adresse mes remerciements le plus vifs à Eleanor Sharpston. La proposition de son nom en tant que titulaire de la chaire Francqui a été accueillie avec le plus grand enthousiasme, tant par le conseil de la faculté de droit et de criminologie que par les conseils d'administration de l'ULB. Notre seul regret est évidemment de ne pas avoir pu organiser cet événement en présentiel, comme on dit. Madame l'avocate générale honoraire, chère Madame Sharpston, si on était dans un auditoire de l'ULB, je me serais physiquement retourné vers vous. Je me tourne maintenant virtuellement vers vous pour vous exprimer à quel point nous sommes ravis de vous accueillir et d'avoir l'occasion et la grande chance de bénéficier de votre cycle de conférences. Je vous remercie d'être ici parmi nous. Je remercie également toutes et tous de vous être connectés et je laisse maintenant la parole à la présidente de l'Institut d'études européennes, Ramona Coman, pour son mot de bienvenue à elle.
Merci beaucoup, Monsieur le Vice-Doyen. Dear colleagues, dear students, ladies and gentlemen, good evening. It is a privilege and an honor to welcome Eleanor Sharpston to the Université Libre de Bruxelles and to the Institute for European Studies this evening. As we all know in this audience, the rule of law has attracted considerable attention over the last decades. While in the 90s, after the fall of communism in Central and Eastern Europe, the rule of law was one of the most powerful legitimizing ideals. In recent years, this common value of the EU has become one of the bonds of contention. On the one hand, in some EU member states, political parties have come to power with the aim to dismantle the post-1989 liberal or political order. In the name of sovereignty, the governments of some countries seem keen to alter the foundations of their political regimes by overriding constitutional principles and putting under strain the rule of law and independence of their judicial systems. New tools have been established at the EU level to deal with the rule of law concerns in EU member states. But the tools have developed have not yet prevented some governments from democratic backsliding and the deterioration of rights and values. As we all know, at the end of the last year, after several intense political negotiations, a new regulation was adopted on a general regime of conditionality for the protection of the EU budget. This regulation, which was accepted reluctantly by the governments of some member states, will be probably challenged to the Court of Justice of the European Union soon. The rule of law concerns are not only related to the democratic backsliding in some countries. At a more general level, the rule of law has been also challenged by the COVID-19 pandemic. Emergency measures have been adopted, which are not without risk, as in some cases, power might be centralized, rights are limited, and many exceptions are introduced. So the COVID-19 pandemic adds a new challenge to democracy and the rule of law in the EU and in EU's member states. There are many other examples which illustrate the importance of the rule of law debate in the EU today. Eleanor Sharpston will contribute to current academic debate by addressing the question of the rule of law within the law of the European Union, which is a new and very important angle to previous debate on this complex and important topic for us scholars in European studies. So on behalf of the Institute for European Studies, Emmanuel Bribosia, Vice President of the Institute, and I would like to thank Eleanor Sharpston for giving us the opportunity to shed light on a series of important legal questions on the challenges of the rule of law within the law of the European Union. Thank you very much. And avant de terminer, permettez-moi de remercier à mon tour la Fondation Francqui, la Faculté de droit et de criminologie de l'ULB, le Centre de droit européen et plus particulièrement Cecilia Liscala, chercheur postdoctoral FNRS, et Emmanuel Bribosia, vice-présidente de l'Institut et professeur en droit européen pour la coordination et l'organisation de la chaire. Merci beaucoup. Je passe la parole maintenant à Emmanuel Bribosia, vice-présidente de l'Institut d'études européennes.
Mesdames et messieurs, en vos titres et qualités, chers et chers collègues, chères étudiantes, chers étudiants, Dear Eleanor, comme l'ont souligné Vaios Koutroulis et Ramona Koman, c'est un véritable honneur de vous accueillir à l'Université libre de Bruxelles au titre de la chaire Francqui et de pouvoir bénéficier de votre enseignement sur ce sujet tout à fait fondamental qu'est l'état de droit. Vous accueillir virtuellement, certes, étant donné que vos leçons, à commencer par cette leçon inaugurale, devront être dispensées en ligne en raison de la crise sanitaire que nous connaissons. Nous ne doutons néanmoins pas un instant du fait qu'elles n'en seront pas moins passionnantes et instructives. Une femme passionnée et passionnante, vous l'êtes assurément, comme en atteste tant votre parcours que vos nombreux écrits, qu'ils soient académiques et rédigés en tant qu'avocate générale à la Cour de justice de l'Union européenne. Il suffit d'un bref regard sur votre carrière pour se rendre compte de sa richesse et du caractère tout à fait exceptionnel de celle-ci. En droit de l'Union européenne, vous avez en effet à peu près exercé toutes les fonctions et abordé toutes les matières, du monde académique à celui du barreau et de la magistrature, du droit de la concurrence à celui de la non-discrimination ou au droit de l'asile. Peu de méandres du droit de l'Union européenne semblent en effet avoir échappé à votre voyage professionnel. Ce parcours présente également la spécificité d'être cosmopolite et multidimensionnel. Né à Londres, d'une mère irlandaise et d'un père lituanien, votre enfance est ensuite partagée entre le Brésil, la Suisse et l'Autriche. Polyglotte dès votre plus jeune âge, vous débutez ensuite des études de latin et de grec, d'économie et puis de droit à l'université de Cambridge et au King's College London, avant d'entamer une carrière de chercheuse à l'université d'Oxford. En parallèle à vos premiers pas dans le monde académique, vous êtes admise au barreau de Middle Temple en tant que barrister. C'est au cours de votre stage que vous vous frotterez pour la première fois aux institutions européennes. D'abord, lors d'un stage en droit de la concurrence au sein de la Commission européenne, et ensuite à la Cour de justice en tant que stagiaire de l'avocat général Sir Gordon Slynn, auprès duquel vous deviendrez plus tard référendaire. Forte de cette expérience, vous retournez à votre terre d'origine, l'Angleterre, où vous êtes nommé, dès 1990, professeur de droit de l'Union européenne à l'University College London et ensuite à votre alma mater, la prestigieuse Université de Cambridge. C'est ensuite en 2008 que vous serez rappelé vers le plateau de Kirchberg pour y occuper à votre tour la prestigieuse fonction d'avocate générale auprès de la Cour de justice de l'Union. Mandat auquel il a été mis un terme l'année dernière en raison du Brexit, dans des conditions sur lesquelles vous aurez peut-être l'occasion de revenir. C'est en raison précisément de l'exceptionnalité de votre travail à la Cour que nous avons eu l'idée de vous inviter à siéger, il y a exactement un an, dans le jury de thèse de Cecilia Riscala, dont l'étude proposait une analyse transversale du principe de confiance mutuelle en droit de l'Union européenne. À notre plus grande joie, vous avez accepté l'invitation. Et cela nous a donné déjà à l'époque 2 occasions d'échanger avec vous, encore en présentiel, à l'ULB et ensuite à l'Université de Saint-Louis, sur des questions fondamentales liées à l'intégration européenne. Lorsqu'il fut le temps de proposer des candidats ou candidates potentiels pour la chaire Francqui 2021, nous avons dès lors directement pensé à vous. Quel plaisir, en effet, de vous entendre nous raconter le droit de l'Union européenne. Je passe la parole à Cecilia pour la suite de la présentation.
It would be impossible to be exhaustive about your work at the court, dear Eleanor, given the number of distinguished opinions you delivered during your 13 years of service. Passion and significance are certainly still 2 adequate words to describe your work in Luxembourg. Your opinions have indeed always stood out because of their accuracy and their relevance. Let us nevertheless remember 2 of them. The first, the one you delivered in the ANS versus Slovenia case concerning the Dublin system. I very much enjoyed reading your reminder on Europe's geography, which seems to be forgotten by many European leaders. As we know, the Dublin system aims at sharing the responsibilities between the member states with regard to asylum applications lodged within the EU. It assumes, in principle, that the member states of first entry should bear the burden of assessing the asylum application. Nevertheless, as you brilliantly exposed in your opinion to that case, member states are in very different situations regarding migration according to their geographical location. The closest crossing points between the EU and the South, which are the more open to migration, are situated in Malta, Greece, and Italy. Yet, the Dublin system does not take this as a starting point by assuming that migrants could equally join the European territory through all the member states. You briefly stressed the unfairness of this system and the serious violations of the migrant's dignity which could flow from it. Secondly, we will also remember your opinion in the case Associazione Avvocatura, relating to a public statement made by a lawyer excluding the recruitment of homosexuals in his law firm. Quoting Homer, you recalled that words have wings and that they travel fast and spread quickly. Statements made during a radio interview discriminating people on the basis of their sexual orientation by excluding their potential recruitment had therefore, in your opinion, to be considered as hindering their access to employment and as falling within the scope of the Directive 2078, which prohibits such discrimination. The court followed your opinion. These are two examples of opinions between many, reflecting the passion and the relevance of your work as an EU lawyer. They also reflect the humanist values at the core of your commitments, values that we cherish here at the Université Libre de Bruxelles. Our students are therefore very lucky to be able to follow the set of lessons you will provide, focusing on one of these values, the rule of law. We thank you very warmly again, and we will now give you the floor for this inaugural speech. Let me just specify that participants may, during your speech, already send their question through the chat box in French or in English, and that we will collect a few of them at the end of your presentation. Eleanor, the floor is yours.
Ladies and gentlemen, there have been so many kind words in French that I feel that before I start on my prepared text, which will be in English, I am of necessity, I should reply to you in the language of Voltaire. And c'est alors que je prends brièvement la parole en français pour vous remercier de la gentillesse des mots que vous avez prononcés à mon égard. Des beaux compliments très exagérés que vous m'avez fait d'ailleurs. Je tiens aussi évidemment à remercier la Fondation Francqui, à remercier l'Université Libre de Bruxelles. J'ai eu le plaisir lors des deux défenses de thèse de doctorat dont vous avez fait mention. J'ai eu déjà le plaisir de travailler avec vous. Et c'est pourquoi aussi c'était pour moi un plaisir tout à fait particulier d'être invité, de présenter un cours dans le cadre du cher Francqui sur l'état de droit. Et je vais passer en anglais aussi pour ceux qui ne sont pas tout à fait bien dans leur peau en français. And I will, in moving across, I will unashamedly, since Cecilia has mentioned two opinions, I am going to be cheeky and I am going to say there are two opinions, well, there is one already and there will be two, which are opinions written after I left the court, because there are some cases that were in the Grand Chamber where normally I would have given an opinion, but for various reasons, I never was allowed to get round to issuing my opinion. So in one of those cases, which is case C194 of 19, HA, another refugee case, there is in fact a shadow opinion, as it is called, a shadow opinion which is already up there on the blog run by Professor Stephen Pears. And there will be another shadow opinion in two cases concerning the Islamic veils. These are the follow-ons to Bugnawi and Ajbita. And that shadow opinion, those cases are cases C80418 Vaba and C34119 Müller-Handels. That shadow opinion, which I'm actually still writing at the moment, will probably be up there something like the 19th of March. And then after that, if I may be a classicist for a moment, after that, this gladiator tends to take her wooden foil and leave the arena with having stayed alive during the period of the games and move on to other things. But since the EU taxpayer has actually paid for a lot of work on those cases, it seemed to me only honourable to try to make that material public. Now then, let me move across from there to the subject of this evening, and I gave it the title, Taking the Rule of Law Seriously, but what does that actually mean? Well, as has been mentioned, I used to be for many years an academic in Cambridge, and this phrase, the importance of the rule of law, is one of those phrases that we teach undergraduate lawyers. Usually we do that in one of the very early lectures in the Welcome to Studying Law course. It appears under the guise of the general introductory comments about how important is this new career on which you are launching, and there are some rotund phrases about the importance in a democratic society of the rule of law. And in peaceful, tranquil times, really, there's no issue about that. The undergraduates are there, they make a dutiful note of what you've said. They do know that it's unlikely to be something on which they will be examined at the end of the year, but they make a note nevertheless. And we all stifle a yawn, and then we move on to the rest of the lecture. Well, during today's lecture, I would like to try to do the rule of law a little bit more justice than that as a topic. So I'm going to begin by mentioning some of the components of the rule of law, components obviously that derive from multiple sources. And some of these are the components that I intend to be exploring in greater detail in the 5 two-hour sessions that I shall be devoting to particular aspects of the rule of law over the next 3 weeks. There isn't time to do all of the rule of law. That would need a lot more than 10 hours worth of lectures. But having done that, I want to look actually in more detail at a number of recent developments over the last few years, both in the United Kingdom, the context being inevitably Brexit, and in the European Union, other problems and Brexit, that have put the rule of law under the spotlight. I shall also argue that in so doing, they have in fact highlighted its potential fragility. And conversely, these have, I think, also shown us how really essential for the well-being of our democratic institutions and way of life it is that we should entrench and defend the rule of law, even when this is politically unpopular. Well, I mean, we could spend some time, and I probably shall spend some time tomorrow, tracing the development of the concept of the rule of law. In practical terms, this is part of a pushback against the absolute rights of absolute monarchs and absolute despots. An absolute king with ultimate power has the right to be completely arbitrary. The king wants X to happen, so that is what will happen. And nobody says to the king, "Oh, but your majesty, that wouldn't be terribly right. Why are you doing that? What about the right to a fair trial? What about? And then at a certain moment, people do start to push back, whether that is the barons under Magna Carta, or its later development of the idea that, maybe actually we're not subjects and we don't have kings, we are citizens. Being a citizen is, I think, a very important transitional point here. Citizens expect, even if life is rough, they expect to have rights. Whereas subjects, well, the very term subject rather implies that you're not going to have rights. Then, of course, we have our different constitutional traditions, and some of them explicitly and others of them implicitly begin to develop catalogues of rights that are seen as part of the rule of law. So then we can start looking at our international instruments. We look at the International Declaration of Human Rights. We look at the European Convention of Human Rights, of course. And then for those of us who are EU lawyers, we seize with pleasure upon the Charter of Fundamental Rights. And we go through and we have fun deciding whether it's rights or principles that we're looking at. And we also congratulate ourselves because the Charter is, of course, a much more up-to-date rights document than the ECHR. And so inevitably it has more elements in it. And one of the questions we might ask ourselves if we're being deeply philosophical is when we speak of the rule of law, what should we be including in that rubric? And why do certain things make the cut? Why do certain things get included? And why do other things not get included? Maybe I shall be exploring that over the course of the next 3 weeks. So now we have a little bit, I'm feeling cheeky this evening. I'm going to be cheeky and say this is the trailer for the movie. During the next 3 weeks, there's a number of aspects of the rule of law that I will be looking at. The areas that I've decided to concentrate on are ones that I think usefully illustrate the issues about the. They also, of course, which are ones in which over the years I have had the occasion to work, whether that was as an academic or as a barrister or as an advocate general, or indeed as all of the above. So one of the first things that it would be helpful to think about, perhaps, is the rule of law and access to a court. It's not much use, you know, having substantive rights if you cannot actually get before a court in order to claim them. And so that immediately raises the question, who can bring what before a court and why? Why are they let in through the door? If we look at one of our very early and very well discussed EU law cases, Van Gent and Loos, is EU law, as was being argued, just a new contract between states? And if somebody does something which breaks the agreed rules, for example, increasing the customs duty on urea formaldehyde, is that something that only a state or the Commission can complain about? No, says the court. No, says the court. This is something which under our new system is an actionable right. It is a right that an individual gets, an individual customs agent in Van Gent. And they can assert the right not to be charged the higher duty on urea formaldehyde. Or to take another very well-known case there, Les Verts. Do we have a closed list of who has locus standi to get before the court? Or should we be applying some more functional test and look at whose rights are being affected? And if your right is being affected, then maybe you should be let in through the door. Are you let in through the front door for a direct action? Can you only get in through the side door via a reference for a preliminary ruling? My predecessor as Advocate General, Francis Jacobs, wrote a wonderful opinion in the UPA case in which he pointed out that the front door is rather narrow and the side door is sometimes closed. And then all these things that you read in EU law about a complete system of remedies, is the system in fact complete? Or are there holes in it occasionally? And when the court says, no, it's meant to be a complete system, everyone is not necessarily happy with that idea. There are complaints about the court being too creative, being too teleological. And then, all right, let's assume you have access. You get in through the door. Access in itself is, I would suggest, inadequate, unless once you're actually there before the court is prepared really to review the decision that is being challenged. So what is the intensity of review that you're going to get? Are you going to get just a procedural review, a very, very technical, I'm tempted to say perhaps slightly superficial review? Have they kept the exact rules on time frame, on saying they've looked at things, they being the administration, or have they really looked at it? What is the intensity of review you're going to get in, for example, competition law? And what is going to be the institution's margin of discretion? Are they going to be given lots of discretion when they're doing something which is economic and complex, like, for example, running an agricultural market? Or are the limits to that discretion that are set by fundamental principles and set by concepts of the rule of law? Let's move on from there. In her introduction, Cecilia was kind enough to mention one of my refugee cases. Let's move on to the refugee crisis and the rule of law in that context. These decisions under the Dublin regulation, AS, Jafari, Mengistabe, all of that. Is the Dublin regulation just an agreement between the member states as to who's responsible for processing an application for asylum? Or are the people being processed actually people, rather than, you know, statistics on a sheet? We have N thousand people we need to process. Oh dear, that's a lot of people. Maybe we can get rid of these ones to some other member state because they came into that member state first. So thank heavens we can get rid of them under the Dublin III regulation and have fewer people to process. But what about the people who are being moved around like this from one member state to another? Do they have a right to go to a court to say, I don't think the criteria were applied correctly in my case? The argument that's always made against that is, oh, floodgates, the court system will collapse. You know, there'll be so many applications. What price exactly do you put on access to justice? And should individuals be paying the price of a hypothetical floodgate if there is, as they would argue, real injustice in their case? A question we might like to think about. So there's the reviewability of decisions under the Dublin regulations, and then there's contesting solidarity. I'll come back to that a bit later in this lecture. What about terrorists? I've just had the pleasure today of sitting in the jury for the PhD soutenance of Elodie Sellier. She's just written a very, very big thesis looking at coherence and law in this area. Rule of law and the rights of the terrorist subject. Well, when the court produced the Cardi 1 judgment, and there were people who either thought it was wonderful or other group of people who thought it was an absolute abortion. What was the court doing, getting in the way of UN Security Council regulations? Alternatively, what was the court doing, or what would the court have been doing, had it not felt that there was some right for an individual person affected by these decisions to say, actually, you've got it wrong? And there are all sorts of sub-issues that come through there, including some really important trade-offs that need to be managed. A lot of what is done in relation to terrorist cases depends on intelligence that comes in from the field. If your person who's on the wrong end of a listing decision, the alleged terrorist, is to have a right to challenge that decision, then they have to know what the case was against them, and they need to be able to challenge it. That sounds simple enough. It's rights of the defence. Then you talk to people who work in intelligence and who work in counterterrorism, and they remind you that if information gets through which enables somebody working in the field who was the source of that information to be found and identified, the person in question may disappear and reappear as a headless corpse in a ditch. This is not necessarily a game that is being played by everyone according to gentlemen's rules. So there are some real issues that come up here. And then, of course, on my shopping list, final element of the trailer for the movie, then there's the rule of law and the independence of the judiciary. Because if we are going to speak about independence, then we want to have independent courts. And if we say independent courts, independence implies also freedom from political influence, but it implies a degree of structural or functional independence for the judges. And there's a number of points there that we might want to pick up. I will pick up one or two of them a little later on. So, I mean, that's just a few brushstrokes to sketch out the kinds of issues that are going to arise as you start to apply rule of law principles in those areas. And I look forward into getting into more of the detail in the teaching sessions that start tomorrow. But now let's go and illustrate some of these problems, these issues. Let's have a look at what's been happening recently, both in the state with which I'm most familiar, the UK, and in the European Union as a whole, in relation to some of these aspects of the rule of law. I'm going to begin with the UK. And as I'm sure many of you know, the UK has always prided itself on having an unwritten constitution, which is buttressed by constitutional conventions. There's no problem. We don't need one of these funny continental written texts, because we all know how this is meant to operate. We all keep to the unwritten rules, and we all behave like English gentlemen, or not. Unfortunately, and I do say that word with both regret and shame, Brexit has shown how vulnerable such constitutional arrangements are when the system comes under pressure and when the political desire is to do X at once and the law is perceived as getting in the way. So here are 3 Brexit examples, and then a 4th very recent non-Brexit example, which is to do with balancing effective access to a court against protecting society against terrorists, or maybe terrorists. My examples. First example is the first Miller case. This is the case which was about parliamentary approval for the UK to send an Article 50 letter to the EU announcing its desire to withdraw from the Union. Did that need parliamentary approval, or was it something that could be done by the executive acting on their own? From a rule of law perspective, it shouldn't really have been such a big deal. The UK is a member state which goes on and on and on about the sovereignty of Parliament. I think we all know that. We've all been told that so often over the last 4 years. Yeah. So it doesn't seem very unusual to think that the constitutional requirements of the United Kingdom, to pick on the wording of Article 50, the constitutional requirements of the United Kingdom would probably include a requirement that it should be Parliament rather than the executive that decided whether to send a letter under Article 50 TEU to the European Union, giving notice of the United Kingdom's intention to leave. Parliamentary sovereignty? Parliamentary approval, no? Well, apparently it was a very big deal indeed. 3 members of the divisional courts said that it was necessary to get parliamentary approval, and the next day the front page of one of the tabloids produced photos of the 3 and the headline, "Enemies of the People." It pilloried those judges. And then there were briefings against the suspected Europhiles in the Supreme Court. Ladies and gentlemen, all the judges involved made it painfully clear that the case wasn't about Brexit in the sense of, are we for Brexit or are we against Brexit? It was about what is the correct procedural mechanism for launching Brexit. But that did not stop the press entirely misrepresenting the case. Example number 2, the second Miller case. Gina Miller is a good fighter. The second Miller case. This was the case about proroguing Parliament for 5 weeks out of the 8 weeks between the end of the summer recess and what was then the exit date on the 31st of October 2019. So the UK, I mean, I know the date has moved several times, but at the time, the UK was scheduled to leave the EU on the 31st of October, and the Prime Minister advised the Queen to prorogue Parliament for 5 weeks. The effect of doing that, very convenient effect, was to close off most of the possibility for parliamentary debate and scrutiny of anything to do with Brexit. In the Supreme Court, there were 4 issues. Is the question of whether the Prime Minister's advice to the Queen to prorogue Parliament, whether that advice was lawful, is that question justiciable in a court of law? Can you even go to a court of law and ask that question? Now, you might think under many systems with written constitutions, you wouldn't need to ask the question because surely it must be a matter of constitutional law what happens with Parliament sitting. But because of the way it works in the UK, this was actually a real question. Was this justiciable at all? Next question, if it is justiciable, by what standard is its lawfulness to be judged? Third question, by that standard, was what happened lawful? And fourth question, if it wasn't lawful, what remedy should the court grant? Interesting, the Supreme Court was unanimous, 11 justices, unanimous in their replies. Yes, it's justiciable. First question. Second question. Prorogation will be unlawful if, and I quote, it has the effect of frustrating or preventing, without reasonable justification, the ability of Parliament to carry out its constitutional functions as a legislature and as the body responsible for supervision of the executive. The court will intervene if the effect is sufficiently serious to justify such an exceptional course. Please note where the barriers, where the various hurdles are being put in that. Preventing without reasonable justification, the court will intervene, the effect sufficiently serious, and this is going to be an exceptional course of action for the court to intervene. And then the court said, actually, you know what, we're intervening. There was no reason, says the court, let alone a good reason. There was no reason for a 5-week prorogation. Therefore, this was unlawful. And because the Prime Minister's advice was unlawful, it was, in that wonderful, very English phrase, it was null and of no effect, as was the order in council making this happen. And the actual prorogation, they must have had fun writing this, you know. The actual prorogation, I quote, was as if the commissioners had walked into Parliament with a blank piece of paper. The prorogation was unlawful, null, and of no effect, and it followed that Parliament hadn't been prorogued at all. Now, so far, it looks as though the rule of law is doing pretty well. My third example. My third example is the infamous UK Internal Market Bill. When this bill was introduced in the House of Commons, the Northern Ireland Secretary, Brandon Lewis, who was introducing it, was very open and transparent about its provisions. He said, quotes, "This does break international law, but only in a very specific and limited way." End of quote. As drafted, the bill would have overridden Article 4 of the withdrawal agreement between the EU and the UK. Article 4 says that the withdrawal agreement takes precedence over UK domestic law in relation to customs checks on goods arriving in Northern Ireland and Great Britain, and it's also about what constitutes state aid. I'm not totally sure I would describe that as very specific and limited, but that may be in the eye of the beholder. What then happens is pretty dramatic. We have the resignation of Sir Jonathan Jones, a very honourable man, the Treasury Solicitor, and the Advocate General for Scotland, Lord Keane. So the chief legal advisor to the government resigns, as does one of the three government law officers. All three law officers seem to have been in agreement as to the legal effect of the bill where it's become law. And of course, what any individual regards as a resigning matter is between them and their conscience. The other two didn't resign. It took a major revolt against the bill in the House of Lords, not just from the usual suspects, you know, the lawyers, whom you'd expect to stand up for the rule of law, not just the lawyers, members of the House of Lords from all walks of life, trade unionists, Tory grandees, diplomats. And this was also against the background of this, it was a breakthrough on the Trade and Cooperation Agreement being negotiated with the EU. Finally, the government got the message and backed down and dropped the offending clauses from the bill. So it never passed into law, but there was a lot of willingness, apparently, on the part of the government to put in place a statute on the statute book, which, on plain admission, broke international law. It may perhaps not surprise you. I don't think breaking international law, which that bill blithely proposed to do, is a great idea. It's not good as a matter of law. Pacta sunt servanda. It's not good as an example to other nations, particularly when it comes from a very old, well-established democracy, which has always prided itself on its intrinsic respect for fundamental values. It's a really bad example coming from the UK. It's not even good as a matter of realpolitik. If the UK is a sovereign state that cannot be trusted to keep its word and respect what it's just signed, why would you want to sign a new deal with it? So, you know, whichever way you look at it, it is an extraordinary approach to take from a government. But there we are. The fourth example I'm going to mention is one which is, I think, describable as news that's hot off the press. It's the judgment of the UK Supreme Court that was handed down on the 26th of February 2021, so on Friday of last week, in the Shamima Begum case. The bare bones of that are that Shamima Begum, when she was 15, left the East End of London and went off to become a jihadi bride. The way that the Home Secretary, that fine and honourable man, described it when he wrote to her saying that he intended to have an order made to deprive her of her British citizenship, gave us the reason for the decision that she was a British Bangladeshi dual national who, it is assessed, has previously travelled to Syria and aligned with ISIS. She was 15, okay? And it was assessed that her return to the UK would present a risk to the national security of the United Kingdom. So he made an order depriving her of her British citizenship on grounds of conduciveness to the public good. Now, she wanted to challenge that, unsurprisingly. She was actually not, of course, in the UK. She was in a camp, in the middle of nowhere, and the conditions in the camp were fairly atrocious. She had given birth to children who had died, but very specifically, in the context of mounting a challenge to the decision depriving her of her citizenship, conditions in the camp did not in any meaningful way allow her to see her lawyer or give instructions for the conduct of that case. And she applied for permission to return to the United Kingdom, as they say, outside the immigration rules, but permission within the specific context of being able to bring the legal case challenging the order depriving her of her citizenship. The decision that was taken against her had been certified by the Home Secretary as being partially based, partially taken, in reliance on information which should not be made public in the interest of national security, because she was suspected of involvement in ISIS. So her appeal against that decision lay to the Special Immigration Appeal Commissioners. They aligned with the Home Secretary. The Court of Appeal overruled that and decided that she must be allowed to return to the United Kingdom for the specific purpose of challenging, of contesting the deprivation of citizenship. The Supreme Court has just unanimously reversed the Court of Appeal ruling. 5 judges, unanimous. She has no right to return to the UK to contest that decision. And at the moment, she cannot give instructions to contest that decision. In present conditions, she is stuck with the decision depriving her of her nationality. I used to do national security cases for Her Majesty's government. And so I used to see from the inside the sort of material that's there. Yes, of course, there are issues. There are big issues about this kind of material. This case is about whether one can envisage making some appropriate arrangements in order to allow a 20-year-old woman, one 20-year-old woman, to be physically present somehow in the United Kingdom in order to have a fair trial. And the ruling of the UK Supreme Court is extremely deferential to the Home Secretary. Does that ruling strike a balance in a good place? I wonder. I'm looking forward to discussing that in one of the sessions. Let's move across from there to the European Union. And the rule of law, the état de droit, is of course a leitmotif of EU law from early days, because the memory is still pretty raw in continental Europe of what it's like when you don't have the rule of law. We don't want to go back there. But unfortunately, in parallel with Brexit and all that, the EU has been having some rule of law issues of its own. Again, 4 examples. Example number 1, the refugee reallocation saga, the solidarity aspect of that. We have the 2015 refugee crisis, and in that context, there are 2 council decisions based on Article 78 TFEU that introduced provisional measures for the benefit of what were called the frontline states, Italy and Greece. And the idea was, put to one side what happens under Dublin III, we're going to reallocate some of the applicants for international protection who've turned up in Italy and Greece, we're going to reallocate them to elsewhere in the EU. The first of those decisions reallocated 40,000 applicants. The second decision, a mere week later, reallocated a further 120,000 applicants. We are talking enormous numbers because there is a real crisis going on. The Slovak Republic and Hungary challenged the legality of the second of those decisions. The challenge was unsuccessful. I mean, so far so good, you know, it's their right to test the legality of a decision that they did not like before the Court of Justice. So far, fine, no problem. But what then happens is that 3 of what are called the Visegrad member states, so Poland, Hungary and the Czech Republic, those 3 member states nevertheless basically refuse to implement the decisions. The Commission brings infringement proceedings against them. Put it at its simplest, those 3 member states were declining to apply an EU law which had already been reviewed and upheld by the Court of Justice. Not a law about which you might have some doubts, because it had been exhaustively and elaborately checked for validity by the Grand Chamber, and the Grand Chamber had concluded there are no reasons to doubt the validity of this decision. But they argued they had a get-out-of-jail-free card. They argued that was so because Article 72 TFEU preserves member states' rights to exercise the responsibilities incumbent upon them with regard to the maintenance of law and order and the safeguarding of internal security." End of quote. They felt that it was not conducive to the maintenance of law and order and the safeguarding of internal security to have all these extra refugees turning up, and so they didn't need to comply, did they? Well, I have to say, I was the Advocate General in the case. I was not impressed by the argument. I'm happy to tell you that the court wasn't very impressed by the argument either. Example number 2, the Polish judges saga. There's lots of cases about what's been happening in Poland in relation to judges. I'm going to refer here just to one of these, which is the C619 of 18 Commission against Poland. This is the case about lowering the retirement age for judges in order to get rid of lots of incumbents. There's an awful lot in that judgment on independence of the judiciary and associated with the requirement that courts be independent, a requirement that there be rules that protect serving judges. Rules as regards the appointment, the length of service, the grounds for abstention, rejection and dismissal of members of courts. Rules that are, quotes, such as to dispel any reasonable doubt in the minds of individuals as to the imperviousness of the court to external factors and its neutrality with respect to the interests before it. So it's essential that there are things like guarantees against removal from office. And the principle of irremovability requires that the judge can stay in post to the end of their mandate, if the mandate's for a fixed term. It's not wholly absolute, but the only exceptions to the principle are exceptions that are warranted by legitimate and compelling grounds subject to the principle of proportionality. Just remember those words for a little while, will you? Because I would like to come back to them. So this is the second example. The third example is naturally the wider issue, the rule of law problem in Poland and Hungary. I'm not going to talk about ongoing proceedings. It wouldn't be proper for me to speak about the hearings under Article 7.1 TEU. I am going to mention an editorial that came out on the Verfassungsblog, again, as it happens on Friday, by the founder of the blog, Maximilian Steinbeiß. The editorial is entitled Wolves and Men, and the way that he puts it is, in the post-Brexit EU, the heads of governments in the council decided in December that they wouldn't have their brothers, Poland and Hungary, cut off financially by some supranational rules of law, just because they happen to have some problems with the rule of law. So they wrote in some things that should apply instead. Parliament could have appealed this, but Parliament Legal Service wrote down all kinds of reasons why a lawsuit was pointless and impossible. I don't know what's going to happen on that, but I was interested to see that those were the comments. And there's a very big analysis by Alberto Alemano, in fact, up on the Verfassungsblog on precisely that point. This is going to bring me on to what I'm afraid has become known as l'affaire Sharpston, which is getting rid of the last British member of the Court of Justice. Some members of the academic community have already expressed themselves eloquently on this topic. I think I should begin by saying I really wasn't seeking to cast myself in the role of Joan of Arc or Martin Luther. That was not part of my intention. Let me try to outline very briefly, very objectively and very neutrally what this was all about. Brexit happened, as you know, at the end of January 2020. The mandates of the UK judges at the court and at the General Court either ended automatically on that date or had already ended, and the post of judge from the member state had also ceased to exist. That left the Advocate General. There isn't a legal link between an Advocate General and a particular member state. There is a non-binding political link inasmuch as Declaration 38 to the Treaty of Lisbon records a political agreement between the member states as to which member state can put forward a candidate when there's a vacant Advocate General's post. And so you have the inconvenience, you have a sitting Advocate General who has a mandate which was due to expire on the 6th of October 2021. Politically, a perceived need to have pureté institutionnelle, therefore to get rid of me because I was a British nominee, notwithstanding the fact that I am in fact a dual national, Luxembourgish as well as British. Legally, it's not absolutely so obvious that my situation was the same as that of the judges. And there are 3 issues in l'affaire Sharpston. There's a substantive legal issue. Did Article 50, Para 3 TEU automatically bring my mandate to an end upon Brexit? That's the substantive legal issue. So far, it's not been adjudicated upon by any court. A political decision has been taken as to what the answer to that question is, but no court has ever looked at it, still less decided it. Then there's a separation of powers issue. Can the politicians decide what legally Article 50, Para 3 TEU did or didn't do? Is that something the politicians decide? Or is it meant to be something that's decided by a court? Bearing in mind that under the statutes of the court, which is EU primary law, it is the court that decides whether the rather restrictive conditions have been fulfilled, according to which a sitting member should no longer serve. And then there's a jurisdictional issue. I should say, by the way, I requested formally that the court should decide my situation under the statute, and that request was rejected administratively by the President of the Court. Then there is the jurisdictional issue. If the member states issue a declaration saying that a serving member's mandate has ended and there is a vacancy to be filled, and or if they take a decision appointing a replacement member to the court, does an EU court have jurisdiction to review that decision of the member states? So those are the 3 issues behind l'affaire Sharpston. Then you have some rather messy litigation. And then you have the events of September 2020, where there is a very limited freezing order, an ex parte freezing order on the 4th of September that suspends the decision appointing my successor. And it suspends it for a very limited period of time until the defendants in T55020R could lodge observations and he could hear the application for interim relief inter partes. There is an appeal against that immediately lodged. The appeal is not notified to me as the applicant. So my lawyers and I are completely unaware of the fact that there is an appeal. On the 10th of September, the Vice President of the Court made 2 ex parte orders, allowing those 2 appeals, dismissing the entire application for interim relief, and indeed expressing the view that prima facie the General Court had no jurisdiction to entertain the actions involving the member states. The court instantly swore in Advocate General Rantos, and once he had been sworn in, after he had been sworn in, the Vice President's orders were notified to my lawyers and myself, and with them we received the appeal documents, which had been lodged 5 days before. That was the moment at which we saw the text of the appeals. As a lawyer, I do not have a particularly good explanation to offer you. I can understand why, given what the Vice President had written in her ex parte orders, the General Court on the 6th of October then decided to dismiss the cases before it, because I can understand, I'm not saying I would agree with it, but I can see that they may have felt they were in a difficult position. I'm not really sure why everything happened as it did. I am, if you like, political reasons, I'm tolerably certain that the fact that this coincided with news from the UK that Her Majesty's government in the Internal Market Bill was openly contemplating breaking international law and breaking the withdrawal agreement probably didn't do me any favours. But I mean, that's a pure hunch on my part. Now let's stand back and look from a rule of law perspective at what has happened. These events were a gift to every bug-eyed Brexiteer and populist. I paraphrase comments that have reached me. Who would want to be part of such a nakedly political organisation with its Mickey Mouse court that, as we always knew, has no real independence or legitimacy? And it is so hypocritical to tell Poland off for interfering with its judiciary and then defenestrate, chuck out a serving member of the court without anything resembling due process. That's a summary of what's fed back to me. And it makes me very sad. It makes me very sad because I have served the European project all my adult and professional life, and I do believe that on the whole, the European Union is a union governed by the rule of law. And that is why I have appealed the General Court's orders in T18020 and T55020. These are now pending before the Court of Justice as case C68420 and C68520, respectively. I have, of course, no idea what the court is going to do with the appeals. I'm going to speak very much as an academic, not as a litigant. It seems to me that from the rule of law perspective, there are two possible paths, either of which would go a long way towards repairing the damage. Both would involve the court actually making, as it were, a real reasoned ruling on the point. One option is that you accept jurisdiction on the basis, applying the Lever line of case law, that the member states' collective action produce results within the European legal order that has affected a third party, and you go on to rule on the substance. If that is what happens, whatever the outcome is, I would be content, even if the outcome on the substance is against me, because that would be a victory for the separation of powers and for the rule of law. That's a possible option. Another possible option is to produce a careful, well-reasoned judgment that analyses the issues, that acknowledges the problem, and that concludes, however, that the court doesn't have the power to fix the jurisdiction issue. If you like, a judgment very like the court not following Advocate General Jacobs in the UPA case. Advocate General Jacobs was given locus standi, and the court said, no, actually, we don't think we can do that within the treaties as they stand. So such a judgment would say, look, we can't fix it, but it would go on to invite the member states as the masters of the treaty, the Herren der Verträge, to make the necessary changes in order to ensure for the future that the court is demonstrably and objectively fully independent. And that would also be a very good outcome from the perspective of the rule of law. There is, of course, the possibility that the court won't do either of those. It may be, I have no idea, but it may be that the court will decide to get rid of these very tedious appeals, as we used to say, par la petite porte, which is court speak for dismissing them by reasoned order. And if that is what happens, then, you know, we probably will, almost certainly will, end up in Strasbourg. We'll end up in Strasbourg before the Human Rights Court, and we will all have the fun of discovering just what the Bosphorus presumption of compliance with fundamental rights actually means. I have no idea what's going to happen to these cases. I do emphasise, because this is important, there is no monetary claim. I'm not looking for money. I'm also under no illusion that I'm somehow get my job back. My service at the court has ended. This is litigation on issues of principle, jurisdiction, separation of powers, a decision by the court on the underlying substantive issue. These are purely and simply issues about the rule of law. I'm going to conclude. I hope you will allow me to quote what I said in my opinion in the Visegrad cases, because I said some things there about the duty of sincere cooperation solidarity and the rule of law, because I meant what I said there, and actually I still passionately believe that it matters. So I quoted the preamble of the TU. I stressed, as the preamble does, that the rule of law is a universal value that is part of the cultural, religious, and humanistic inheritance of Europe. And it's a value that the member states have confirmed they're attached to. And Article 2 TU gives substantive effect to those recitals. It explains that the Union is founded on values of respect for inter alia, the rule of law. And then I mentioned I mentioned at a deeper level, respect for the rule of law implies compliance with one's legal obligations. Disregarding those obligations because in a particular instance they are unwelcome or unpopular is a dangerous first step towards the breakdown of the orderly and structured society governed by the rule of law, which as citizens we enjoy both for its comfort and its safety. Now, look, sometimes the issues about the rule of law are big attention-grabbing issues. Military coup in Myanmar, a populist President Trump in the USA denying the outcome of democratic elections and urging his followers to insurrection, followed by voting according to party lines under cover of a very nice legal fig leaf in the subsequent impeachment proceedings. More often, I suggest to you, the rule of law is the inconspicuous grey cement that holds the bricks of society and democracy together. We need that cement. Therefore, please, those who are politicians, statesmen in positions of power, those who are able to influence them, people who are tempted to take shortcuts when the law is tiresomely getting in the way of what you want to do, please remember we need that cement. And please, all of you who are fellow lawyers and fellow citizens, and all of you who care about the rule of law, if you see that vital principle being breached, please have the courage to stand up and to call it out, because that really matters. Thank you very much.
Thank you very much, Eleanor, for this passionate and very, very inspiring speech. I think it was really important to recall the importance of this value, and you really pointed out the threats that exist on it. It was very instructive, of course, and it also makes us look forward to the lessons you will give in the next weeks. So we have already two questions from the participants, and I will call to all the audience that they can send their questions in the Q&A session of the live event. So the first question is, what do you think about the appointment of international judges, CGU and ECHR, in terms of independence? Many critics have been raised. Are these courts legitimate to scrutinize the independence of national judges? And you already tackled a little bit this issue, but this question was also raised by one participant. And the second question is, do you think that the judgment delivered by the European Court of Justice on the independence of the judiciary in Poland will be an efficient tool on the ground to protect the rule of law in this country? We can maybe start with these questions, and if the participants have other questions, do not hesitate to publish them into the chat. Thank you.
All right, it's a nice, lively start to our question and answer session. I think the first question about the appointment of judges to international courts is a very important one, because if we decide that those courts are going to patrol and adjudicate upon instruments that sovereign states have signed up to, that itself is an expression by the sovereign states of their willingness to buy in, that they're prepared to submit to the jurisdiction of the court. There was actually a separate process for the ECHR about buy into the jurisdiction of the court. And one of the elements of being a member of the EU is that you buy into the jurisdiction of the Court of Justice. Now, for all this to work, there are several bits that I think are important components in the story. One is that the people who get nominated to the courts have to be people of quality. And the Strasbourg system has the system of approval by the Parliamentary Assembly. And since the advent of the Article 255 Committee, the Court of Justice and the General Court also have a vetting committee, a committee that gives a positive or a negative assessment on the candidates. And I think initially it was felt that perhaps the Article 255 Committee might be a bit of a rubber stamp, and the committee has demonstrated that it is anything but a rubber stamp. There have been a number of negative decisions, and probably an important moment was reached when there were negative decisions not only against one or two smaller member states, but there were also negative decisions against bigger member states. And a certain point was reached where, if you like, there was peer pressure that since a number of member states had negative decisions in respect of their would-be candidates, if another member state had such a decision and started to say, well, I don't think we should pay any attention to the committee because actually its ruling is not binding, there is peer pressure at that point to say, you know, sorry, we accepted what the Commission said about our candidate, so you're going to have to live with what the committee said about your candidate. That peer pressure is important. I think the issue of the length of mandate and whether the mandate is a fixed mandate or a renewable mandate is also an important issue. As I'm sure most of you know, the mandates in Strasbourg are single mandates and they're non-renewable, whereas the mandates at the Court of Justice are renewable mandates. And there is certainly an argument for saying that if you have a renewable mandate, that does expose the member of the court to the possibility, I'd say, it's not exactly this pressure, but they'd like to be reappointed. By the way, the Advocate General is, if that argument is right, the Advocate General is much more vulnerable than the judge, because the Advocate General has spent the previous 6 years writing opinions, individual opinions, and signing them. So if you want to know what Sharpston thinks about something, all you have to do is read what she wrote. Whereas the judges are acting collectively within the framework of a single collegiate judgment. And so they are much less vulnerable because they're much less visible. It's much less clear what their individual thinking is on any particular individual point. It is, I think, and it's the third point I'll make, I think it's also about the quality of what is written. International courts don't operate by sending in the bailiffs. They operate essentially because what they say is intellectually coherent, it hangs together, it's well reasoned, it's convincing, and it carries the conviction with that. And that puts a real premium on the quality of the legal reasoning, and also on making sure that you do not, because there is a pressure of time and work, you do not allow judgments to go out which haven't had time really to be bolted together properly. There is a temptation because of the pressure of work, and because you know perhaps what the conclusion is, to say, well, we know what the answer is, and here's a text which more or less gets us there, and so that's good enough, let's get on with the next case. I think that is dangerous in a big judgment from an international court. I think it is a false economy to say, let's get that judgment out quickly. It is more important to spend an extra 2 weeks, an extra month, a further discussion between the judges to try to make sure that the quality of the reasoning is solid, is coherent, consecutive. You shouldn't be able to say, and sometimes people do say, I can see where the scissors went across the page and a paragraph was taken out, but they didn't write something to put in place of what was removed. The second question, will the Commission Poland judgment be an efficient tool on the ground, on the rule of law? Well, I don't know that I have very useful observations to offer on that. There are people who know the situation in Poland much better than I do, who have been writing very, very frequently in the academic sphere about what has been happening in Poland and about the problems for the independence of the judiciary. I think the court has said, if I say what it said is fine as far as it goes, the court has made some very useful and important statements in the Grand Chamber judgment that I cited about what independence means and what the necessary parameters are to guarantee that independence. What will in fact happen next, I'm not in a position to say.
Thank you very much, Eleanor. We are going to follow up with other questions that were raised on the chat box, and I'll just read 3 of them. The first one is linked with issues of women and LGBT plus in Poland. And the question is, could the rights of women and LGBT plus in Poland become an issue of the rule of law? This is a first question. A second one is linked with your case, if I may say so. And the question is, if this case would go before the Court of Strasbourg, don't you think that the case would be inadmissible, ratione personae, or would it be directed against the United Kingdom or all the member states? How would you see that in practice? And the third question, I read it, is what is the relationship between the rule of law and democracy as values enshrined in Article 2 TEU? Is there an overlap between the two? May a line be drawn? Do you think judges and other jurists can effectively sustain the rule of law in adverse political circumstances if the political institutions of a given polity do not also protect it, and for how long? Would you consider that the notion of rule of law in Article 2 TEU is a thick constitutional notion providing for a strong protection, or a thin international law notion aiming at a bare minimum formal content? So I give you the floor back with those 3 different questions.
Yes. I am a little reminded of the old advice that you should not write on both sides of the paper at once when attempting to answer this exam question. I'm really not sure I understand the third question. It is much too subtle for me. If the question is, can the judges uphold the rule of law if the politicians won't? There is, in most democracies, there is a degree of tension between what the courts are doing and what the politicians would like. In most civilized democracies, The politicians grumble if the courts do something that they don't like. The courts are careful to point out that if Parliament really doesn't like it, they've always got the power to change it. And the courts are also careful not to be too creative too much of the time. This is all about nuance. And I don't think that you can give an answer to the question, can the judges uphold the rule of law? I will give an answer to the question, should the judges uphold the rule of law? And the answer to that question is absolutely they should. And I have no hesitation in saying that. And they should uphold it absolutely irrespective of whether they think it's politically popular. They are not there to tailor what they say to political popularity. And if they are doing that, they're not being faithful to their judicial oath. But I'm also, I feel uncomfortable about the question to thin or thin concepts. I think because I'm a working lawyer and always have been, and I was a working advocate general, I think that the proof of the case is usually in what actually happens. The proof of the theory is in what actually happens in cases. If you make a statement of principle, rights of the defence are a good thing, we'll all agree with the statement of principle, yes they are. Now let's see what actually happens in a sequence of cases in which the argument is made X or Y doesn't respect rights of the defence, and see what the decision is of the court in those cases. And then we will know from that whether in that particular legal system the rights of the defence are a thin notion or a thick notion. But I really don't think you can answer the question in the abstract. Could there be an issue about the rule of law in Poland, the LGBTI? Yes, there could be an issue. What's going to happen? I don't know. I don't have a crystal ball. I'm really sorry to disappoint, but I don't. I wasn't issued with a crystal ball when I joined the court, and I didn't take one away with me when I left the court. I left in rather a hurry, of course. It's possible that if I had left more slowly, I would have been able to find a crystal ball and take it with me. But I didn't have time to find a crystal ball. As for whether my case in Strasbourg, should it go to Strasbourg, be inadmissible, I will begin by saying I hope it doesn't go to Strasbourg. I have no desire to take a case to Strasbourg. I hope that the Court of Justice with the appeal will decide to do something sensible with the appeal. And I have stated, and I do emphasize, I've stated as an academic, not as a litigant. I have stated as an academic two possible ways forward that seem to me as an academic to be ways of dealing with the situation. The line of evolution which might lead to Strasbourg would be a line of evolution in which the Court of Justice dismissed for lack of jurisdiction the appeals that are before it, doing, so to speak, the same as the General Court. At this stage, you have to hypothesize what would the reasoning be. If the reasoning were, these are acts of the member states, you've got some defendants there that are not the EU, you have defendants who are the member states, and you have an argument that they are responsible for a violation of the right of access to a court, and the violation is happening within the context of EU law, but it is an act of the member states. In a sense, I don't think you can discuss, I've given you some strands, but I don't think you can sensibly discuss admissibility about a hypothetical case that hasn't happened yet, right? And you can't discuss it on the basis of not knowing what would be the judgment of the Court of Justice, which would be the step before such an action was contemplated, because there are so many unknowns in the story. It depends on how you write what. I'm not going to speculate beyond that. I can see there are ways that something could be written which would make it not impossible to go to Strasbourg.
Okay, thank you very much. Eleanor, we still have 2 questions in the chat if you agree to answer these questions. So the first question is, you mentioned the refugee relocation saga as an example of the EU rule of law issue. I was wondering to what extent EU refugee and migration governance can as a whole be considered a part of an EU constitutional transgression. Apart the relocation saga, the Common European Asylum System and Schengen have been nullified in practice, and lawmaking in this area has moved to wholly informal procedures. While there have been attempts to resolve the implementation deficit in relation to the Common European Asylum System, there has been none in relation to Schengen. To what extent this implementation deficit can be considered as an issue with broader implications for the EU project? So that is the first question. And the second question, I would like to ask Madame Sharpston, what role does she think legal education has in promoting the rule of law? In fact, it's a set of questions of the same person. My second question would be with regards to the recent judgments of the European Court of Justice in regards to the European arrest warrant. Is there a way the EU can go around the Visegrad Group blocking the application of Article 7? And more importantly, should the EU try to go around it? And thirdly, does Madame Sharpston think that soft law undermines the rule of law, or rather deems that it fills nicely the gap between hard law and not no law at all? Thank you.
There are lots of implementation issues in relation to EU asylum policy, because it is complicated and difficult and politically sensitive, but also because it deals with human beings who have rights, and it deals with access to the court, but it also, as soon as you have access to the court, you ask, yes, but access to the court, to what extent? We already saw a big shift, I think it might be fair to say, from the Dublin II regime and the Grand Chamber ruling in Abdullahi to Dublin III with its Article 27, and the rulings of the Grand Chamber in Geselbach and Karim, and later in Sherry. And there are many cases that have already come into the system, and I'm sure there are many more that will continue to come. And I have absolutely, I wish my former colleagues at the court courage and intelligence and intellectual integrity combined with humanity in deciding those cases. Do I think that legal education is important? Yes, absolutely. I think I'll go further than that. I don't think legal education for lawyers is what we should be talking about. I think we should probably be talking about a wider type of legal education for citizens, that citizens should be given more information while they're growing up about what holds society together and what matters and why it matters. It is unfortunately very easy in most member states to come through the school system and come out the far end with rather little in the way of ideas and understanding about the responsibility of citizenship as compared to one's knowledge of mathematics or biology or French literature or whatever else it was you were studying for the back. And I think that's unfortunate. Does soft law undermine the rule of law? No, it doesn't. It complements the rule of law. and I'm going to give you as an example, rather interesting example to my mind, of soft law moving across to be primary law, which is, of course, the Charter of Fundamental Rights, which began as soft law. It would never, I think, have got through as hard law. If it had been tried as hard law, it would never have been adopted. It was adopted as soft law. And then gradually there's an evolution, there's a move forward, and gradually we move across from it being used as soft law and as a soft law tool of interpretation by the court. And then we get the transformation with the Treaty of Lisbon and the statement that the Charter has become primary law at the same level as the treaties.
To go further on the Polish question, the famous LGBT-free zones clearly hint at discriminations in Poland. It is doubtly that towns who proclaim themselves to be free of LGBTs would hire them and treat them accordingly to EU law. It is likely that rulings happen on this matter both by the European Court of Justice or by the ECHR. But wouldn't the recent Weiss decision by the German Constitutional Court be a huge threat to the rule of law that would be followed by Poland's Supreme Court and lead to a complete destruction of the European rule of law, especially on discrimination matters by states such as Poland and Hungary, and probably others, considering the new rise of the far rights in many countries?
Not necessarily. I mean, there are so many superlatives in that statement that the answer has to be not necessarily. Nothing in law is as black and white as that question implies. And I don't myself, but I may be wrong in my reading of the Bundesverfassungsgericht decision in Weiss, I do not regard that particular decision as being, the catastrophic decision which pretends the collapse of the European Union of its central court. I'm sorry, I don't read it as that. And so we have had, ever since the beginning of the European Economic Community, we have had a degree of tension, and there's nothing actually wrong with a degree of tension, between the Bundesverfassungsgericht and what's been happening with EU law, EEC law, as developed by the Court of Justice. And we had Solange I, and then we had Solange II as the EU law moved on. And then we've had various other judgments. I mean, you know them as well as I do. There's a whole catalogue of judgments. Why should we think that the judgment in Weiss suddenly pretends the end of civilization as we know it? I don't think it does. This is there is a serious issue underneath this, which is not helped by, with all respect, is not helped by superlatives. There is such a thing as a dialogue des juges. There is such a thing as the fact that we have within our continent, right? We have constitutional courts, supreme courts and constitutional courts in member states. We have the court in Strasbourg, and we have the Court of Justice of the European Union. Some of the jurisdictions overlap. Each of the courts in question is legitimately watching out for what is within its jurisdiction and making sure, judges would like to comply with their judicial oath. They would like to do what they are meant to do, what they said they would do when they were sworn in as members of the court. So they are patrolling what is within their territory, and that's perfectly okay. That's what they should be doing. And one of the reasons that courts talk to each other, and they do talk to each other, there are lots of judicial exchanges between the Court of Justice and individual Supreme Courts in member states. There is an annual dialogue between the Court of Justice and the Strasbourg Court, which is indeed given the nickname of the dialogue des juges. It is the reality that judges talk with each other and they try to see where difficulties arise, where sensitivities exist, and they try to be respectful of each other. They don't actually go out there squaring up for fights. So, you know, I don't think that portraying what is said in one or other decision as, you know, automatically nuclear is actually a helpful way of looking at it. I think it is usually better to stand back and say, what was that actually about? What did they actually say? Are the procedural reasons why they said it in the way that they said it? You know, now let's calm down a bit and look where this is actually taking us. I'm sorry, it's a very pragmatic answer that I've just given you, but it's the answer of somebody who is, you know, kind of used to working with the fact that different courts at times issue judgments which you need to think about and bear in mind.
Thank you very much, Eleanor. Le moment est maintenant venu de clôturer cette très belle leçon inaugurale de la chaire. Selon les mots que Eleanor Sharpston a utilisés elle-même, elle nous a livré un trailer, et un excellent trailer qui nous a donné envie justement de pouvoir suivre les leçons suivantes et approfondir chacun des aspects reliés à cette notion d'état de droit appliquée à l'Union européenne elle-même. Et on retiendra aussi l'expression et l'intensité avec laquelle Eleanor Sharpston a terminé sa présentation en parlant du Simon that holds the bricks of society and democracy together. Et on a vraiment besoin effectivement de ce Simon, de ce ciment. Et donc, on a aussi retenu l'invocation du courage à se lever et à se battre pour ce rule of law qui est absolument essentiel. Je suis convaincue que ça résonnera particulièrement aux oreilles de nos étudiantes et étudiants qui ont pu écouter cette leçon, et bien évidemment également aux oreilles de tous les collègues et de toutes les personnes qui nous ont fait le plaisir de participer à cette session. Je voudrais encore vraiment remercier chaleureusement toutes les personnes qui ont rendu la tenue de cet événement possible, remercier également évidemment Eleanor Sharpston d'y avoir participé, et surtout vous rappeler que nous avons déjà la deuxième séance demain matin à 10h sur Teams, et donc ça nous donnera l'occasion d'approfondir grâce au récit et à l'exposé toujours extrêmement clair de Eleanor Sharpston, The Rule of Law, Why It Matters. C'est le programme pour demain matin, et ensuite les autres séances suivront la semaine prochaine et la semaine d'après. Vous avez tout reçu normalement si vous êtes inscrit donc à l'ensemble des séances de la chaire. Donc, merci encore à toutes et tous. Thank you, Eleanor, and see you tomorrow. Bye bye.